Happy Good Friday. All right. In echoing what Kelvin has said, again, I think let me also just re-echo it, to thank you for joining the session today. I think it's quite important, given that it's a Good Friday. So yes, happy Good Friday to you also. But I'm going to do two things this afternoon. We'll speak about the topic, which is the art and the science of preliminary meetings. But before we go there, I just wanted to be sure that all of us were carrying on and we're all on the same page. And so therefore, class is going to be quite interactive, just like the other classes. And I'm going to be working with about 5 of us, in this first part of this evening's engagement. And so in the last 6 weeks, we have engaged with very seasoned legal practitioners, both in country and outside of the country. So we've had Fola Adeola. Fola Alade. Fola is a seasoned mediator. Is somebody I'm very proud of. Aaron Ogletree is from the United States. Aaron is an attorney, is an arbitrator, and is somebody who is quite deep in knowledge. Laura Alakija, my sister, spoke on investment arbitration. Laura is also someone I have a lot of respect for. And then we brought Fola back to speak about emotional intelligence. Now, if you look at the trajectory of how we have been discussing or what we have been discussing, we have been going into substantive matters in relation to dispute resolution. And then, of course, we got my brother, Rotimi Ogunyemi, who spoke to us on online dispute resolution. And so you can see that the curriculum is deepening itself in a way and manner that is preparing us, for the possibility of you either playing as an arbitrator or a member of a panel or as counsel. One of the key things we considered when we set up this school was to develop seasoned counsel and seasoned arbitrators. And the reason is largely because we had been dealing with all types of nonsense in court or even in arbitration in terms of awards. And this is as a result of, poorly trained lawyers or poorly trained arbitrators. And so we're trying to put all of this together. And so in the next 90 minutes or so thereabout, I want us to now get a bit more practical. I want us to look at the procedural part of what we're also going to be doing. Or what we're already doing. And so we'll be looking at the preliminary meetings. What does the preliminary meeting mean? We're talking about the art and the science of preliminary meetings. What does it really entail? Is it necessary? Is it important? Does it even elongate the process of hearing? And I'm going to be sharing my platform this afternoon. Just tell me, and it doesn't matter whether you get it right or you don't get it right. This platform is a platform where all of us are going to be sharing knowledge. And so let me start with Indy Diamaka. Indy Diamaka, you can put on your video and your microphone. What do you think preliminary meetings? What do you think it means? Can Indy hear me? Indy Diamaka. Oh dear. All right. Comfort Ayla. Is Comfort with us? All right. I'm sure you do. Okay. Is happy to join. All right. Comfort. Excellent. Thank you. Thank you. Thank you. What do you make of procedural meetings? What does it mean? Or preliminary meetings, I beg your pardon. What does it mean to you?
Well, it's the meeting you have before you go into the real arbitration process itself. And it's getting to meet with the parties involved. Everything that is more or less like you having an introductory meeting. Maybe I should round it up like that or summarize it like that. Like you are having an introductory meeting prior to the real arbitration itself, where you get to meet the parties, introduce the parties, you tell them about the rules governing the arbitration, every other thing that needs to do prior to your starting the arbitration process in actual. Let me put it that way. I don't know whether I'm right.
Fantastic. No, thank you very much. Thank you very much. Amira, do you agree with Comfort Tanila? Do you agree or disagree with her?
Yes, I do. I agree with Comfort.
You agree with her?
Yes, I do. I agree that a preliminary meeting
Okay.
is anything done before the main arbitration
Is
process.
there anything you disagree with about what she has said?
No.
Right. Okay.
So far, I agree with everything she said.
Okay. And I think, all right. So you agree with us that it's in domestic arbitration, for example, it mirrors what you can call a case management meeting, right? Amira, can you hear me?
Oh, yes, I can hear you now.
I said it mirrors a case management meeting. Is that correct?
Yes. Yes, it does.
Right. Thank you. Thank you. Kainde Idowu, any thought from yourself? Is Kainde Idowu with us? Okay, I see that Tolua Tosin Akintoye wants to jump in. All right, Tosin, go for it. What are your thoughts on preliminary meetings?
Well, as for me, I think preliminary meeting has to do a, a, a meeting where the parties have to meet. It doesn't necessarily entails the main case management conference. They have to meet to discuss the entirety of the matter in preparation of what to expect in the case management. That is what I think, sir.
Thank you. Thank you. Thank you. All right, so we all got it right. Calvin, can you please help me share my slides? And we can delve straight away into this afternoon's topic. I think all of us are right. It is a in domestic arbitration we call it case management meeting. It's a meeting where you tidy up all what would either become loose ends, is an opportunity for you to deal with matters relating to the timetable and quite a number of other things. Kevin, are we able to share my slides? Let me see whether. Kelvin, are you with us? Can you help me share my slides, please?
Yeah, you can share from your end, sir. You have been made co-host.
Okay. It's not giving me that. Share the screen. Okay. Okay. Can you see my screen?
Yes, we can, sir.
All right, thank you. Okay, so this
Yes, we
afternoon,
can.
yes, we'll just be speaking about purpose, what I call purpose, and then between the meeting and the oral hearing. Now, under the comfort, Amira and Idowu Kehinde were all right, speaking to what those meetings are. Now, usually when you're about to comment an arbitration, remember I said we had focused on the substantive issues. Let's now look at the procedural matters now. Now, once you serve a notice, once a tribunal is constituted, the first engagement is usually the preliminary meeting. And that is the first time the tribunal is engaging formally and maybe physically as well with the parties and with counsel. Now, I thought, and I'll be emphasizing some points here so that as we're going, please note that those emphases will be useful to you whether as an arbitrator or whether as counsel. And these are some of the nuances that we find which create some sort of challenges when we go on. So once the tribunal is constituted, the first engagement which the tribunal will call for will be the preliminary meeting. Now, if you look at all the line items, I will pick them one by one. Now, this is the focus really of what your preliminary meeting, what it would look like. And the first item there, I had said, is the confirmation of tribunal's legitimacy and jurisdiction. Now, that first one is so important because it's the bedrock of what donates powers to the tribunal. We have seen many instances where this singular point has derailed an entire otherwise very sensitive arbitration. And so usually sometimes the tribunal will gloss over it and assume, particularly in situations where you do not even have an arbitration clause in your contract, and then parties have found their way to go before an arbitrator. I'm sure during Q&A we'll be able to explain that a bit more. So the first thing the tribunal must do, or the first thing you demonstrate the tribunal's legitimacy and that jurisdiction. And what legitimacy is it I'm talking about is the fact that both parties agree to submit to the jurisdiction of this particular tribunal, whether it's a single man panel or whether it's a three-man panel. Now, what this means is that neither party can come around much later to say, look, oh, I do now challenge the jurisdiction of this tribunal. Now, let me be clear. The challenge of the jurisdiction of a tribunal can go on, throughout a hearing. However, once a smart tribunal has quickly introduced this at the start of the hearing itself, then it limits, not eliminates, it limits the incidence of a party trying to stall the arbitration, challenging the jurisdiction of the tribunal. Now, very closely related to that is to also confirm the extent of the powers of the tribunal. Now, in a hearing, every of us know that arbitration, one of the attractions of arbitration is that there is party autonomy. And that is why it's different from traditional litigation, etc. But at the same time, you also want to check and curtail the types of powers that is donated to an arbitral tribunal. And I give you an example. So matters that parties do not agree to in their contract, matters that parties do not agree to in preliminary meetings such as these, exercise powers over. And so let me give you, for example, we were in an arbitration many years ago. And in that particular arbitration, we agreed what the method of communication was. And the method of communication in that particular hearing was via email only. And for whatever reason, the tribunal decided to overlook that agreement and chose that it was going to mix methods of communication, whether by emails, whether by post letters, or whether by telephone calls. And in that arbitration, the tribunal told us, look, I have wide powers to do and undo. And said, no, it cannot be, because the entire process is being driven by the parties. And so the parties must, every smart lawyer now must ensure that you identify what the key powers you want to donate to the tribunal. Otherwise, you discover that the tribunal will run the entire process or the entire proceedings based on how it feels, it should go. Party autonomy is king and is key in arbitration, and that's one of the attractions of arbitration. So the powers of a tribunal is one of the key points that comes up during preliminary meetings, and usually the tribunal will itself invite parties to discuss to what extent do you want me to demonstrate powers, or to what extent are the powers that you want to give me. Thirdly, the tribunal also, now this is for the tribunal, also want to be sure who the party representatives are. Just last week, we were dealing with an issue where the parties who signed the contract, right, were not the parties who issued the notice of arbitration. Now, not really too different, but there were some mild or minor differences there. And so at the preliminary meeting, it's the duty of the tribunal to want to be sure that the right parties were before it. And so that whoever the award is going to go for or against will be the proper parties, as would have used in traditional litigation. Number 4, method of communication between tribunal and parties. Now, every experienced tribunal and every experienced counsel, this is another point which I'd mentioned earlier, that parties must agree with the tribunal. And this is important because sometimes, so let me give an example. When you're submitting your memorials, some tribunal members will simply just want you to send it by email. Some other tribunal members want you to send it by hard copy document, whilst some would rather you put it on a flash disk. Now, some tribunals will have you put it on all three. Some other interesting tribunal will also ask you that, look, when you are printing your serving us your memorials, let it be on A4 and then give us another one on A5. And so once I questioned it, I said, look, why are you doing it? He said, well, we agreed during the preliminary meetings. And the reason was because, look, when I'm traveling, I want to have copies that are handy for me to take along with me. When I'm in my study room, I want to be able to sit and read, bigger copies. So different nuances for different, different tribunals. But it is at the preliminary meeting stage that we all discuss this, we all agree. And then usually you also make sure that you agree with what is convenient for the tribunal. Decision on any preservative orders. I think this is one of the very important, particularly for disputes that are in relation to matters which the rest may or may not be destroyed. It's always very important for the tribunal to ask. And as you know, a tribunal cannot grant a coercive order, of court. And so if there's any need for any of the parties to seek and obtain any of such orders, it's at this stage that the tribunal would also, quickly inquire whether you have started already, or you are in the process of starting, or is something, that you are thinking about. Now, when you have a multilingual party base, or where the parties are from different countries. This sixth or seventh point is very important. A reaffirmation of important choices, language, applicable law, and place and seat of arbitration. Now, usually, when we are drafting arbitration clauses, we always ensure that those clauses they cover, some of these points. But you can tell that you can never be 100% certain that some of these things will not slip. And so, what the tribunal will do during the preliminary meetings is also to reconfirm, and that is why it's a reaffirmation, that look, this is the language of the contract, and in cases where you need to vary it, it might also be at this point, where both parties can agree. For example, you want to require to have an interpreter. So it's at this stage that you also be able to put that into. Same thing for the applicable law, same thing for place, and same thing for seat of arbitration. With respect to place and seat of arbitration, it's usually very important that both parties and the tribunal, you agree at this stage what that means. Now, clearly in all various texts we have read, in all books we have published, and in many places where we've spoken, I think the concept of the place and seat of arbitration is abundantly clear. That the place of arbitration is the physical place where parties can sit, where the seat of arbitration is the juridical seat, which is the law that governs it. Now, when you look at some contracts, they are interused wrongly. And so I've seen contracts where they have said, oh, the seat of arbitration shall be Lagos. Or shall be anywhere in Lagos, not Lagos, shall be anywhere in Lagos. Now, the seat of arbitration cannot be anywhere in Lagos. It's the juridical seat that governs that arbitration. Now, anywhere in Lagos could be the place. So, whereas the law could be, Nigerian laws, we can say the place of arbitration. Let me give a good example. So, we had an arbitration some years ago. The place of arbitration was London, United Kingdom, and the seat of arbitration was Nigeria. Now, the place could be anywhere. We could be sitting in Hawaii, we could be sitting in Bahamas, inside a room, and the law that governs that arbitration is Nigerian laws. So usually, but when you find a recalcitrant arbitrator, so there was one Supreme Court justice, retired Supreme Court justice, I will not mention his name. We had an arbitration before him, and he was almost patently biased towards, the other side. And he said he was just granting orders and granting orders. And we said, no, you can't keep granting orders, because what you're doing is against the Nigerian laws. Oh, and he said, no, look, I mean, he was going to move the arbitration anywhere. We said, oh, you can't. In that particular arbitration, we even agreed where the place will be. That's another point. So we agreed that the place of arbitration will be in Abuja. And he said, no, it could be anywhere, and he could move it anywhere. That didn't sound logical to us at all. And before we knew it, the man was going to make an order. So we had to quickly rush to the Federal High Court to obtain an order restraining that fellow. The Supreme Court Justice of England, of an English court, will never confuse a place and a seat of arbitration. But again, those are things that you will find as you go on, on this journey. And so during preliminary meetings, it's quite important that at that level, you also want to be very clear as to what it is that you guys have agreed to. Accelerated hearing is a lot more prevalent nowadays, particularly with some particular types of transactions or disputes. And so a tribunal will want to ask both parties during preliminary meetings whether, if you don't have a duration within which the hearing should start and be completed. And there's a bigger argument regarding, okay, don't let me go into that just now. We'll come back to that much later. But I'll talk about it regarding limitation of time and enforcement. But we'll come back to that later if we have much time. But talking about accelerated hearing, at the preliminary stage, the tribunal should sit with the parties to determine how quickly do you want to start and finish this hearing. Number two, if you want to start and finish it on time, then how? The how is what both parties will now have to decide. And one of the how could be, look, if you want to go the full-blown oral hearing, then that is all right. We'll go through the entirety of it. If you look at the dispute itself and you consider that, look, you know what, on document only, I mean, we've had a document only, and we're concluding one now, a document only arbitration. And, you know, yes, it's taking a bit of time, but, you know, smooth sail quick. And it's also cheaper because you spend less, you know, time having, you know, fiscal meetings, having to pay for venues, etc. So it's at the preliminary meetings where, you know, this is also dealt with. Now, one important part of the preliminary meeting is a discussion of the claim and the defense. It may not be a deep discussion, but the tribunal wants to have an idea. And the reason why the tribunal wants to have that idea is because of the second point, which is the order of pleadings. And so the claimant will be invited to give what you might call a synopsis or an overview of what your case is. And same thing with the defendant or the respondent, as you like. And in the course of listening to both of them, the tribunal will easily be able to guess whether, or most likely, there's probably going to be a counterclaim. Now, whilst these are all good procedural points, it also helps the tribunal to start thinking about its own fees. Remember what I said? We're taking this holistically. So whether you intend to want to branch as an arbitrator or you want to branch as counsel, these are some of the things you need to start considering. So when you are sat in a room as an arbitrator in a preliminary meeting and you are running through each of these checklists one by one, one of the things you're looking at is you're looking at substantive, you're looking at procedural. You also have to look at your fees and how do you charge. And so once you see that in the cost of submission, and I mean oral submission, nothing, some tribunal will ask that you put something in writing. We try to discourage it. I mean, what you can have is an opening statement. So when you have in your opening statement, by the time I'm finishing, you know, it's almost clear. Although sometimes respondents or defendants will still insist to the tribunal that at this stage, I'm not very sure, you know, whether or not it's something I'm considering. Again, because you know that whenever you file a counterclaim, it also forms part of the basis by which the tribunal will charge. The order of pleadings is also a very important point, which also flows from the précis of the claim and the counterclaim. And the order of pleadings, now, you can decide to choose whichever one you want to. We've been in hearings where we've had statement of, so SOC means statement of claim, SOD means statement of defense. You could call it point of claim or point of defense. It's all a matter of nomenclature. The structure and the substance, you know, remains the same. Now, where it becomes tricky is what are the, you know, reactions to your statement of claim and your defense. So in some cases, you will have, most likely you have a reply. And sometimes it ends at the reply. In some cases, when issues are raised in the reply, you also want to give the claimant a right to rejoinder. I've been in a hearing where we also were given a right to sole rejoinder, and in another hearing where we're given a right to sole rejoinder. And then after that, one of the panel members said, look, what are you guys talking about? We're not going to have an end to this litigation if you guys keep, you know, and you know the nature of lawyers, we will always continue to do this. So during your preliminary meetings, a good tribunal will quickly, and you should try and streamline it. Don't make it too long. So you give a statement of claim, you give a statement of defense, you give a reply, and maybe if there's counterclaim, is at this point that you also will file it. And then you can do away with all the sole rejoinders and sole rejoinders. It just makes argument on ending. Agreement on method of taking evidence and procedural timetable. I think this is one of the most important points in a preliminary meeting. As you know, we don't strictly follow the Evidence Act, but I dare say that the evidence, the principles of the Evidence Act guides, what we do in arbitration. And in all of this, the tribunal also wants to be able to establish a procedural timetable, because the procedural timetable is what also guides the duration of the hearing. Arbitration, one of the things we have said about arbitration is swift, is some of those things were losing their steam now, and we want to try and bring them back, because arbitration really, like I've always said, is not for all cases. I mean, you see landlord and tenancy, disputes, they want to go to arbitration. I said, look, it's a waste of time. Because the truth of the matter is that when you look at the landlord or tenancy case, is either the tenant is holding back or the landlord wants out. You need a coercive order of the court to achieve either of the two. And rarely not going to, arbitration. But so sometimes I see that. So a procedural timetable is at this stage that it is also, set up. And what is a procedural timetable? A timetable that guides every action of each of the parties. When do you file your statement of claim? You do that within 45 days. When do you file your statement of defense? You do that within another 45 days. Is there any period of extension or allowance between, the 245 days? And when do you do, the rest of the other things? So it's at this stage where parties also agree. So preliminary meetings sometimes, they take the whole day. I've been in preliminary meetings where we've had it for 2 days, and it went on like that. And usually very intense but very useful. Terms of engagement of the tribunal. Now, most times, particularly domestic arbitrations, I see this happen a lot, where the terms upon which the tribunal is engaged almost is non-existent. And then the tribunal is now left with that duty to start marshalling, its own needs. Now, it's also in the, and if you're going to go into this as an arbitrator, please, this is an important part of your work, to discuss your fees. And so during your preliminary meetings, you also discuss your terms of engagement. Now, your terms of engagement is just not only on your fees. Sometimes it also deals with out-of-pocket expense. And so if you're giving me documentation, if I'm reading it for 8 hours, if I'm flying for 8 hours, any flight that goes beyond 6 hours, it has to be business class. Any flight that is below 6 hours, I can do economy. All of those things, as mundane as they may sound, you must agree with the tribunal, so that at the end of the day, you must have an agreement which the tribunal and the parties will also sign, because it's a contract. I see that sometimes quite a number of people try to shy away. I said, no, it's a contract between the parties and the tribunal. And so they have to sign the terms of the engagement, of that contract. And finally, gentlemen, issuance of procedural orders. Now, procedural orders, they are the likely outcome of all that we have discussed. So when the tribunal issues a procedural timetable, it also issues an order. And so put it this way, you have a procedural timetable, the first of which will be the submission of the statement of claim, by the claimant. That will be followed by a procedural order of the tribunal. So procedural order are, quote unquote coercive instruments or instruments. I don't know whether they are coercive. Instruments that the tribunal would use to drive or to govern the arbitration, the preliminary meetings, I beg your pardon. So usually that is what, I mean, a few other things might crop in here and there. It's a non-exhaustive list, but usually this is almost about 90%, if not 95% of what you will find during your preliminary meetings. Now, once you have moved from the preliminary meeting, it becomes, a sprint, all the way to oral hearing. And so between your preliminary meeting and your oral hearing, you have confirming tribunal's legitimacy, you have discussed the tribunal's fees, the tribunal would have issued its procedural timetable, as well as orders. You would also have been able to take any jurisdictional challenge. And I'm sure many of us here may also know that, when you issue or when you challenge the jurisdiction of a tribunal, the tribunal itself has the powers to determine, that challenge itself. Is called the competence rule. Is able to look at the veracity of your challenge and determine whether or not it's frivolous or it's not frivolous. And in between this period, you'll have exchanged pleadings, and then you'll be going to closure, preparation of a hearing bundle, which we'll talk about. And then if what you had agreed was oral hearing, or if it's hearing based only on evidence, that's it. But between preliminary meetings and oral hearing, these are the things, that would normally happen. Now, earlier on, I spoke a bit about confirmation of the tribunal's legitimacy. I think I'd like all of us to please take this very seriously. I have seen arbitrations, otherwise very good panel that have, been truncated based on clear legitimacy of the tribunal. And I don't think it's enough just for the tribunal to, because when you're appointing the tribunal or the arbitrators, you will naturally get them to do a conflict check. Now, that conflict check or the report of the conflict check might form the basis of an appointment of an arbitrator. But even after that, you want to sit in your preliminary meeting and want to reconfirm, because it's the first time all of you are coming together and things may have even changed from when the tribunal confirmed, its conflict check and when you are having the preliminary meeting. But more importantly, you want to use this as a smart counsel to also ensure that the other party who had hitherto agreed that, look, legitimacy is denoted with this guy. Now, is somebody trying to speak? Can we please mute? Can we please mute the microphone of somebody's Annabella? Can you please mute your microphone? Thank you, Annabella. All right. So, where did I stop? Confirmation of legitimacy. Yes. Right. Can you still see my slides?
Yes, sir. Yes.
Thank you. All right. So very quickly, I will move to the next item, which is the tribunal's fees. And I think now this is useful for both the tribunal, if you're hoping to be an arbitrator, or if you're hoping to be counsel. I think the question of fees of the tribunal is always very important. When we started this advocacy, one of the cliches was that arbitration, was cheap. It's cheap, it's fast. Today I'm not sure how cheap arbitration is, and I'm just going to be brutally very honest. But again, like I've always said, arbitration is not for all matters, and so really there are some matters that when you look at the value of those matters, it just makes sense for you to go into arbitration. But more importantly, as counsel, this is an area that puts you in a most uncomfortable position, because your client is asking you, why the hell am I going into arbitration? It's almost like a first level to litigation. I'm still going to pay anyway, and it's expensive. I'm going to pay for the arbitrator, I'm going to pay counsel, I'm going to pay for the venue, I'm going to pay for the transcribers, I'm going to pay for the registrars. So when you look at the potpourri of many things you're going to pay on, the client from the word go is, a bit uncomfortable about it. And so that must drive you as counsel here now to be able to negotiate well, with the tribunal. Now we have a fee scale or a fee schedule, attached to the act. But beyond that, we also can negotiate lump sum, into the fees. So, what is the component of the tribunal's fees? I usually call it arbitration fees because you must have clarity of it from the word go. For me, the first one is counsel fees, right? Because most of the time, the lawyers will negotiate arbitrators' fees, forgetting that counsel also has to be paid, right? Now, your role in the transaction is different from your role as counsel in arbitration. And let me also say that, look, in Nigeria, quite unlike the position in the UK, you can use an arbitration of choice. But in Nigeria, it's by a legal practitioner. I'm hoping that has not even changed now, and I don't think it has. And the reason why that is so when you now see that it's by a legal practitioner, right? Who is a legal practitioner is defined in our LPA. And so, quite naturally, a lawyer must represent a party in. So, the first payment item or the first fee item for me is counsel fees. How much are you charging, for the arbitration? The next will be the arbitrator's fees, if it's one or if it's three. Now, the arbitrators will usually tell you, oh, it's a percentage of the value. It's either 5% of the value or it's 10% of the value. Now, when it's a high value transaction, obviously that will not make any sense. Your clients will even, oppose it. And so you have the option, of also negotiating a discounted lump sum figure with the tribunal, not as a matter of right, because if you find very difficult arbitrators, they will simply just refer you to, particularly institutional arbitration. They will simply just refer you to the schedule, of fees, and you have to be governed by that. But with domestic arbitration, I think we still see, a bit of flexibility here and there. Administrative fees is also usually a cost component that is sometimes often glossed over. And what does it? Can I please ask that we all try and mute all our microphones, please? When we get to Q&A, we will be able to put it on, as well as our cameras. And so administrative fees, like I said, is an important which sometimes over it. And what does it constitute? It entails the payment for the registrar, whether you are using institutional or you're using an ad hoc arbitration. The payment of the venue. For venue nowadays, we're gradually eliminating that, particularly, with the advent of technology, and ODR. But you have other logistics. So, for example, you have the transcriber who will transcribe real time, the hearing for parties, so that you can study them overnight and use it to prepare for your case or your trial the following day. So quite a bit of that, and I think so. Fees, I think, is very important. I think parties should be very clear on fees. I think because you need to go to another one is on the counterclaim. Is also at this point that you need to deal with the question of counterclaim. Now, a recalcitrant respondent will simply refuse to pay. And you know what it means once you refuse to pay. What the law says is that the other party will pay. But the party who has refused to pay, right, will not also be the party to file a counterclaim. And the way the tribunal will look at it is that, look, the counterclaim is also the equivalent of a claim. And so if I were charging 10% on this claim, then on the counterclaim, I'm also charging 10%, and both parties will split 50% each. And so what that means is that the other party has the unfortunate incident of having an increased percentage payment in terms of arbitrators' fees. So you must be smart and knowledgeable enough to know when your counterparty is abusing, the procedure to his own advantage. And so some of the times there are some things that you will give, and sometimes I've been in an arbitration which, the respondent was a bit cocky, the respondent was a bit unreasonable, and my client decided for whatever reason that, look, okay, you know what, he was not going to pay, and then filed a counterclaim. So very clearly, you knew that the other party could not afford it. And in that sense, what would have happened? Can anybody guess what happened? Anybody? Okay, let's go on so that we don't lose so much time. Obviously, the hearing, came to a natural end, because the tribunal will not go ahead without being paid for their services. And so payment in arbitration is a big issue, and which I would like all of us to pay close attention to, master it and understand its art, and its science. All right. Jurisdictional challenge. I think many of us here are either lawyers or we're learning students. I think this is a major part of what I like us to take away this evening. Your right to challenge on jurisdiction of the tribunal and what constitutes that jurisdiction. Now, whether it's under our Arbitration and Mediation Act or whether it's under the UNCITRAL rules, we had said an arbitral tribunal shall be competent to rule on questions pertaining to its own jurisdiction and on any objections with respect to the existence of or validity of an arbitration agreement. Objections of the points of defense or reply to counterclaim, once alleged that the tribunal has exceeded the scope of authority, the tribunal may rule on the plea either as a preliminary question or in the final award on merit. A party who nominated an arbitration can also raise an objection on jurisdiction. One point that was left out of here, is that objection on jurisdiction can be raised at any time during the hearing. Now, as a good arbitrator, you must also be firm in your grasp and understanding of what is the breadth or the extent of objections, and also be ready to determine those objections. Now, in determining the objections, you have to be grounded in law, arbitration procedures, to be able to don't just overrule a party on objection who's raised some objections. I mean, the tribunal we had once, the tribunal overruled us and we went to court, and the reason why we went to court was because we felt that we were not given fair hearing. What we raised in the objection, the tribunal did not consider it. Of course, that was many years ago. I mean, now we do know better. Now, there are some matters that so I see some lawyers sometimes they confuse, matters of conflict, or they raise objections based on conflict. In a particular arbitration we had many years ago, the tribunal was accused. It was a sole arbitration. The tribunal was accused of walking out of a conference at a hotel, a public hotel, with one of the team members of counsel on the other side. I mean, we thought that was completely ridiculous and completely, frivolous, and it was very easy for such such an objection to be thrown out. So as an arbitrator, you must be the master. It's called the dominus litis of your court. You must be the master of it. You must know, what ought to what constitutes, proper objection, particularly on jurisdictional grounds. Now, also on jurisdictional grounds, there are some matters that don't go to arbitration. So, for example, criminal matters won't go to arbitration. Family matters won't go to arbitration. I know now that some of our family courts now try to use a bit of mediation, into it, but not arbitration, because arbitration, as you know, both parties must agree. So that element of agreement between the two parties, I think, is also what distinguishes arbitration. And it doesn't matter whether you had a prior agreement before now. What is important is you could even do so by submission agreement now, when the dispute has arisen. Okay, I think we're doing very well with time. A critical point which we had also spoken about, which is now getting into the meat of the procedural matters of arbitration, of the plenary meeting, and arbitration really is your exchange of pleadings. And it's very similar to what you have in the court, just that it is a bit more relaxed, and then the tribunal can or will or normally guides, so for example, the tribunal will say, look, you know what, your statement of claim should be no more, than maybe 40 pages, maybe 45 pages, maybe 50 pages. And same thing for your statement of defense. But your replies, your reply should not be more than 12 pages. I've been in an arbitration where the tribunal said that your replies must not be more than 7 pages, and then rejoinder, 7 pages. For panels that allow you go beyond rejoinder, they just shorten it. In fact, when you get to the stage where you are filing, your written address, the tribunal at some point will tell you your written address should be no more than 2 pages. Now, this is a tribunal that has mastered its craft. And I often say that, look, it makes sense, because when you look at it, all the pleadings you have filed, they're quite voluminous, particularly when you're dealing with very highly sensitive arbitrations. They are highly voluminous, and the tribunal is expected to read everything. But as a smart lawyer, what you must do is ensure that when you are filing your final written address, more often than not, that is what the tribunal will read the last before it starts either writing its award, or it will encourage the tribunal to go and look into all the other things you have filed in the past, which it has read. So your final written address, I think, is extremely important. But let's come back to the exchange of pleadings. And the point I wanted to make here is that, yes, statutorily, we have timelines or timetable. You have 45 days for you to exchange but you don't have to use the 45 days. And that's always been my argument. So a claimant has had all the time in the world to prepare, to go to war. Why should the claimant still take the 45 days? Because when you combine all of this together, that is what makes the life of an arbitration unnecessarily long. So if the claimant can take about 21 days. 21 days, that's about 3 weeks, or even less. Because by the time you're submitting your synopsis, you already have a framework of what your claim is. And so really, what do you need? Another whole 45, almost 2 months to submit a claim. Now, the respondent who was not aware that you're going to be dragging the respondent to court may get 45 days. So the law allows you, but what I encourage is, because the law allows you, doesn't mean that you have to take it. Even in truth, you really want to quickly conclude this hearing. And same thing for what we discussed earlier, whether you want to go through oral hearing or you want to go through on document only. And then when you're submitting your statement of claim, it also has its own structure. And the structure in that statement of claim, you must have the name and addresses of the parties, like I've listed here. You must reference the appointment of the tribunal, the language of the tribunal, and then you must summarize the facts, supporting that claim, as well as general nature of the claim. And then you now start going into what almost is looking like your typical statement of claim, which is the points in issue. You would want to deal with the damages. Now, at this point, they must be well set out, almost like like in normal pleadings. You're telling a story, and in arbitration, you are allowed at that, at this level, to even cite case laws or case authorities, in support of it. We don't encourage it, but if you have to, arbitration is a bit flexible. And then, of course, the documents that support what you have in your statement of claim, also within the same. And the same thing happens to your statement of defense or your points of defense. So it must follow the same, not strictly in this format, but let it have, because this gives the tribunal a total overview, of what your claims are or what your claims should be, and that's what the tribunal wants to understudy. All right. Now, default in communicating statement of claim. We have seen instances where, for whatever reason, a claimant does not file a statement of claim. Now, you will argue that this is quite unusual because the claimant is the originator of the hearing. But we've seen it before. I mean, so it's nothing. So everything you have on this slides are product of what we have seen, and we're still continuing to see in arbitration. And very simple. Once you don't file a statement of claim, that brings an end to the proceedings. If you file your statement of claim and the respondent does not file his defense, the hearing can still go on. You just need to prove your own case. But if you don't file your statement of claim, then it is not going to, such a hearing is obviously going to come to an abrupt end. And you file all your processes, as we have discussed earlier. You come to an end, of the proceedings. If you chose oral hearing, then you go through, the proper oral hearing of your examination in chief, cross-examination, and re-examination. But before you do that, there are some things that you also have to do, which is to prepare. No, I beg your pardon. After you do that, which is to prepare the tribunal for the real work of writing the award. All the documents you have relied upon, all the evidence you have relied upon, you now need to help the tribunal collate it in one single readable format, right? And that one single readable format is what the tribunal will rely on, and what your counsel will also rely on when you're now going into oral hearing, because the process of oral hearing, like some of you may know, can be very tedious sometimes, because you will compile all the pleadings, all the evidence that both parties, and sometimes the tribunal will encourage that if you can file a common bundle. In my experience, we maybe 3 out of 10 we have been able to file a common bundle. Most of the time we end up filing our own separate bundles because we never agree as to what documents should go, as to what documents should not go, etc. And so at the end of the day, the tribunal will ask. Now, when you do that, I must say that it makes the oral hearing a bit more difficult. And when I say it makes oral hearing a bit more difficult is when you now have to start cross-referencing documents, when you are referring to documents during your cross-examination. Sometimes it makes it quite difficult. And I think we're coming to an end of the class, which is now oral hearing. Once you have submitted your common bundle, then the tribunal will engage both parties for a date for oral hearing. In some cases where it is, parties can decide, along the line that, look, it's not having oral hearing may not be necessary anymore for many reasons. I mean, it could be availability of the tribunal, it could be the circumstances of the case that may have changed in the course of the hearing. It could be anything. But at every point in time, parties will continue, to meet and agree on what they consider to be best for both parties, and they go to oral hearing, which is what I've described earlier. Once oral hearing is concluded, the tribunal will invite the parties to also submit final addresses. Again, for those that are familiar with it, I'm sure we know what final addresses are. But for those that are not, final addresses is also a summary or a summation of your case, as you would like the tribunal, to see it. And that document is mixed law and fact. And it's an opportunity for you to restate your case, not in any elaborate manner that will irritate the tribunal, but in a manner that makes it very succinct, for the tribunal to make quick reference to. And after that, the tribunal will adjourn for the award. Ladies and gentlemen, I want to stop there. I want to thank you very much, and let me take some questions. So the entire we've gone beyond the scope of today. The scope of today was to look at the art and the science of preliminary meetings, but you can tell that, you see, for the preliminary meeting, once you start and finish, you have almost gone through the entire gamut, of your arbitration hearing. And we always think it's important that we walk ourselves through every process of it, because every process has a meaning. And so whether you sit on the side of the arbitrator, you must know what to do per time. When the counsel makes a request, you must be quick to anticipate where that request is heading to. And as a good arbitrator, what are you supposed to quickly do to checkmate it? All right. Let me take some questions before we wrap today's class up. So you give me your name and then your question. Okay, I see one in from Ibrahim. Ibrahim, just put on your microphone and put on your camera. Let's engage.
Okay, Ibrahim has put his question in the chat box, sir.
Yes, I said I just wanted him to engage. Okay, what is the question? I can't see.
Can you hear me? Evening.
Oh, evening. I'd like to engage. Thank you, Ibrahim. Please go for it.
Yes, you made mention of our parties choosing documents to present or not to. Am I audible?
Yes, please go ahead.
Yeah, so in normal conventional courts, when it comes to rule of evidence, most times the judges will say, or the law kind of stipulates that even if an evidence is not in support of your claim, it must be presented in court. Evidences must be fair. So does it really apply to arbitration as regarding document to tender and document not a tender? I.e., when a document doesn't really favor your claim and favor that of your opposition, must you tender such a document?
So in arbitration, we're not bound strictly by the Evidence Act.
Evidence, yeah.
And I made that point very clear. But the principles of Evidence Act, so there's also what we call the IB rules of evidence taking. The principles of Evidence Act also guides us. And so, for example, if there's a point that I need to establish, it's incumbent on me to provide all the documents. If I don't even have them, arbitration also allows me, to make an application to the tribunal to get you to submit, those documents. So on document taking, I think it almost mirrors that of a traditional court, but is not as strict as that of a traditional court, where you really strictly rely on primary evidence or secondary evidence. But for you to prove your case before the tribunal, you must put out all the evidence before you, or that you have, and whether or not is. I think the further part of your question, and I must add, I think is also borders on the ethics of our practice. I believe it was Justice Kayode who mentioned it many years ago, that whether or not the document is in your favor, you should tender that document. And sometimes documents that you might think is not in your favor might turn out or end up, being in your favor. What is important is, as ministers in the temple of justice, we also owe the court or the tribunal that duty to put all the facts before them, so that they're able to make informed decision. At the end of the day, what we're looking for is justice. Does that answer the question, Ibrahim?
Yes, it does. Yes, it does. Thank you very much.
Thank you.
Yeah.
All right. Any other question? I see Ladi Joseph Agaba just came in. Do we have any other questions?
Yes, sir.
Ifeoluwa, please go for it.
Yes, good evening, sir. My name is Ifeoluwa Shagwimi. Yes, when you talked about the purpose of preliminary meeting, you made mention of decision on preservative order. I didn't get the explanation. Thank you, sir.
Thank you, Ifeoluwa. So when you're about to start a hearing, we sometimes, or as a lawyer, you must sometimes look at what the circumstance of your case is. And the circumstance of your case sometimes might require you to obtain certain orders preserving the rest, which is the subject matter of the dispute. And I did say earlier that, and when I say rest, I mean, let me try and simplify it. The subject matter of a dispute is a house, and maybe somebody wants to demolish that house, and if you don't quickly stop it from being demolished, it can be demolished. Now, if it is demolished, then it makes everything you're doing, either in arbitration or even in the court, a waste of time. If you went straight to the court, you will tell that the court very quickly will grant an injunction. And like I always like to say, the nature of injunctions is just that nowadays we don't seem to understand it that much. A judge can grant an injunction even from his house. I mean, it's as colloquial as that, not literally. But the point is that, look, the powers of a judge is such that you are able to preserve the life of a rest, so that you don't render the decisions or the outcome of the hearing nugatory. And so same thing applies to arbitration. So when you're going to, into arbitration, and there's a need for you to preserve certain rights, without which, the tribunal or the hearing will become meaningless. It is also during preliminary meetings that parties are able to discuss it. Sometimes some parties are not open enough to say, look, you know what, I need to get a preservatory order, from the court. But there's no big deal about it. And so whether you discuss it there, you don't discuss it there, it's one that you require, is one that you can go for. But what we always advise is, it's a point that you can all discuss during the plenary meeting. And what it does is that it helps the tribunal also fast track, the length of the hearing itself, because that preservatory order, is timeline, and it can be ad infinitum. And so whatever it is you want to quickly do with this particular hearing, then you had better quickly do it. If you're lower. Okay. Do we have any other question? Any other question in the chat box? There's one from Ibrahim. When it comes to, I'm trying to get that question, but I can't seem to get it. Ibrahim, can you? Ibrahim, was that you earlier?
Yes, that was me earlier.
Okay. All right. Okay. Thank you. Do we have any other question, gentlemen? Okay. I see that we do not seem to have anyone. All right. I want to thank all of you very much for your time this evening. I think we have two more, if I'm not mistaken. I think we have two more classes to go. This last 6 weeks has been some experience, and thank all of you for your cooperation. Okay, I see a question from Ifeoma Odega. In a situation where the other party is a
yes, sir.
yes, please
Go
on. I was just say it here since you're go ahead.
Okay. My question is, in a situation where the other party is a foreigner, how will the tribunal handle the preliminary meeting? So at least maybe the procedures, how would they go about it? I want to know that aspect, sir.
All right, thank you, Ifeoma. There's no difference between how the tribunal will handle a preliminary meeting, whether it is an ad hoc arbitration or whether it is an institutional one. It's the same process. The gender, the color, regardless, it doesn't matter at all. Now, what matters, which may be the area where you are, looking at, will be, either conflict of law issues, choice of law issues, issues relating to place of arbitration, or issues relating to seat of arbitration, etc. Right? Or whether it's a purely domestic arbitration. But because there's a foreigner, then you will know that it's an international arbitration. There are some arbitrations that they're domestic arbitrations, but with international flavor. So, for example, you have, one of the IOCs in an arbitration. Very easily, you might, fall in within the mix of thinking it's an international arbitration. But the IOC by law is registered Nigerian company, so it's a Nigerian company. So the short answer to your question is, it doesn't matter whether it's a Nigerian counterparty or it's a foreign counterparty. What is important is what are the line items in between matters of procedural preliminary meetings that are peculiar to foreign parties or to Nigerian parties. Is that all right? If you're
Yes, sir. Thank you so much, sir.
all right. So, ladies and gentlemen, I want to thank all of you. I think we're gradually coming to an end of this particular school. We have two or three more classes if I look at the schedule very well. When we get to the penultimate class, at some point we will like to share your feedback. And like I did say in my opening inaugural speech when we started this school, what I had said was we want to just build, not just book arbitrators. We want to build practical, real life arbitrators and counsel, we've seen that majority of the challenges we have sometimes, is because we just leave everything into the textbook and we don't, practicalize it as we go along, and that's the focus of this school. So I want all of you to please, once we send in that feedback form, give us your feedback, because we're going to, have a second diet. The second diet, the school and the dean of the faculty, we're still looking at it very closely. We have two schools, 149, and the other is 100 and something. So in total, we have almost about 300 or 400, class that we're dealing with. So the second diet, we want to manage it very well. Now, that second diet is going to be a slightly advanced class, where we're going to be dealing with more substantive issues. One other point which I think I'd like us to also please do is, I think Calvin mentioned it last week, every class that we attend, please, let's take one key point out of that class and then let's use it on our LinkedIn pages. Again, this is just not the class. We're trying to build the next generation of commercial lawyers. So pick one point on it, go and use it on your LinkedIn page. You can speak to what you think it means. You can tag us on it or retag many other people. And that is how that conversation, from any of these things, we can start up a conversation. About 3 or 4 weeks ago, I wrote an article, on the asset management company. Yesterday, someone was writing me to ask me to join something. That is how you build your own network as a lawyer or network of lawyers. So please, let's start engaging with you on your LinkedIn pages. And I'm hoping that you all have. If you don't have, I think you should have one. Again, that's a good platform where you can also make commercial visibility as a commercial lawyer or as an intending, commercial lawyer. Otherwise, ladies and gentlemen, I want to thank you for your time today. And I wish you and your families a happy Easter in advance. Mr. Kelvin.